Hello, everyone, and welcome to Uncivil Law. For today's case, we have a situation with cops behaving badly. This is the case of Kerry Morris and Calvin Galloway versus the City of Detroit and Jennifer Lee Adams. In this case, a police officer, while off duty, went to collect a personal debt. The way she decided to collect this personal debt was with her service firearm. She shot someone. That person was wounded. They are suing for relief. Here, the Court of Appeals analyzes whether or not the police officer and the city should be held liable for this. Spoiler alert, the answer is no. So we're going to read this and realize how it is the police can apparently get away with attempted murder. So let's read on. While on duty, Adams went to plaintiff's residence seeking repayment of a personal debt owed to her by Morris, which resulted in a physical altercation between the two women and the discharge of Adams' police department issued firearm. Because Adams acted only in a personal capacity during the incident, she was not acting under color of law, and District Court Judge Avon Cohen therefore granted summary judgment to the defendant. Relying on the same reasoning as the District Court, we affirm this judgment. So this police officer who was on duty and used their department-issued firearm nevertheless was not acting as a police officer. They were only acting in their personal capacity. So don't pay attention to the fact that they tried to shoot you. That was just a personal action, not a governmental action. So it is not a 1983 violation. Okay, carrying on. On June the 20th, 2017, Adams clocked out and left to go to plaintiff's house at approximately 4:30 a.m., even though she was scheduled to work until 6 o'clock. Upon arriving at the house, Adams began to knock aggressively at the door. When Morris opened the door, Adams placed her foot in the door so that Morris could not close it. Adams then entered the house and began questioning Morris about the repayment of a $300 personal loan. Adams became hostile, pointing her finger in Morris's face and initiating a physical confrontation, during which Morris sprayed Adams in the face with mace. After being sprayed in the face with mace, Adams drew her gun and fired a shot. So that's just super fun. So the police officer went to the home to collect $300 like a highwayman, and then got sprayed in the face with mace, and then decided to pull her gun and shoot. Okay, are we sure we're not in Florida? No, we're in Detroit. So I guess it shows there's a little bit of Florida in us all. However, Galloway was upstairs on the second floor. Galloway began making his way down the stairs. Adams threatened him, stating that she would do him physical harm if he came downstairs. Galloway did not intervene in the dispute, but a bullet fired by Adams grazed Galloway, who was in the next room. Shots fired, person injured. This is not governmental action. Pay no attention to the man behind the curtain. After discharging her gun, Adams fled the scene. Galloway called 911. Criminal charges were brought against Adams, but Adams was acquitted of the criminal charges because the state court found that Morris had lied about the incident. So it looks like there are no true angels here after all. Although Officer Adams was charged, thank God for that, they were not convicted because the person decided to lie on the stand. Lying is bad, even when you're the victim. Don't do that. Adams was also suspended after an internal police department investigation determined she violated various police department procedures and policies. Really, the police officer violated police department guidelines. Which guidelines could those possibly be? Would those be guidelines such as don't shoot people when collecting a $300 debt? I don't know, but I think that might be a good guideline. The internal investigation found that at the time of the incident, Adams was not in the police uniform. However, she was wearing her badge. She had a waist-hand holster that displayed her department-issued gun, and she had her handcuffs. Personally, I find that to be kind of uniform enough. If you're displaying your badge, I kind of think that counts, but okay. So we brought the following claims under 1983. False arrest, substantive due process, municipal liability for constitutional violations, and constitutional claims. To prevail under a claim of 42 U.S.C. 1983, a plaintiff must show that a person, acting under color of law, deprived him or her of a constitutional right. The issue in dispute is whether Adams was acting under color of law when she went to plaintiff's home and discharged her revolver. Plaintiffs contend Adams was acting under color of law because she had her department-issued badge, service revolver, and handcuffs, and she was on duty because her shift did not end until 6. Personally, I think that having your badge on you and displaying that kind of counts as acting under color of law. That's what your badge is. It's basically representing that you are acting under the authority of law. So that to me is almost dispositive, but let's press on with what the court says. Whether determining whether a person acted under color of law, the fact that a police officer is on or off duty, is in or out of uniform, is not controlling. It is the nature of the act performed, not the clothing of the actor, or even the status of being on duty or off duty, which determines acting under color of law. We consider certain factors when deciding whether an officer was acting under the color of law, such as whether the officer flashed a badge, identified themselves as a police officer, placed an individual under arrest, intervened in disputes between third parties pursuant to a duty imposed by police department regulations. Courts must consider the totality of circumstances in determining whether the officer was acting under color of law at the time of the alleged constitutional violation. I don't know, man. Once again, personally, it's like if you're displaying your badge, that kind of is like, I'm here on behalf of the law, and you're using your department issued gun. I don't know, man. For me, that kind of feels like enough state action. I understand the point the court's trying to make, but I don't know. That seems, yeah, more than a little bit suspect in my mind. Man, Tobin, you say badge equals cop. I'm kind of with you. That's kind of where I'm sitting on this one. Adams was not in uniform when she went to Plan's house, but she did have her badge, handcuffs, and service revolver. The only item she used during the incident was her service revolver. I'd like to take note that Detroit apparently is still using revolvers. That's kind of cool. I didn't know they were so old-fashioned about it, but all right, they're still using service revolvers. Interesting. All right. Although Adams used her gun, which was state-issued equipment, she did not manifest the requisite showing of state-granted authority to act under color of law. The sole purpose for Adams being at Morris's house was to collect a personal debt of $300. Adams did not purport to be conducting police-related business, nor did she attempt to use her status as a police officer advantageously during the altercation. The fact that Adams used her department-issued weapon, kind of right there is the point where I'm saying she was using her status as a police officer advantageously when she's using her department-issued weapon. You know, saying she didn't use her status advantageously and then saying used her department-issued weapon, those are thoughts that, to my mind, don't really gel in one sentence following the other. But they apparently do to the court because they literally wrote them in that order. The fact that Adams was using her department-issued weapon during a private dispute is not enough to establish she was acting under color of law. Told otherwise would create a federal cause of action out of any unauthorized use of police-issued weapon without regard to whether there are additional circumstances to indicate the officer was acting or actual or purported police authority. I don't know, man. If every time the federal government got involved when a police-issued firearm was used, that might be a good thing. So personally, I'm not seeing the parade of horribles, but okie dokie. The purely private altercation between Morris and Adams does not possess the necessary indicia of authority to find that Adams was acting under color of law. Because the disputed facts demonstrate that Adams was not acting under color of law, plaintiff cannot demonstrate a necessary element of the constitutional violation. Plaintiffs contend the city of Detroit should be held liable for Adams' action because it failed to properly train and supervise Adams, and it permits officers to carry guns when off duty. It is well settled that there's no respondeat superior municipal liability under 42 U.S.C. 1983. This is true. Under 42 U.S.C. 1983, respondeat superior, which is basically because I was employed, my employer is responsible, is not a thing that exists. So just because the agent did something does not make the city liable. Unless you can show the city did something, you cannot sue the city for violation of 1983 just because the agent did something. So that is true. It is well settled that there's not respondeat superior. If a employee from Walmart injures you in some way, you can sue Walmart corporate. But if the police officer violates your rights, you can't sue the police department unless you can show some action by the police department as such. So that is a strange fact of law, but it is true that it is well settled as a matter of law. So that is a thing. You can sue Walmart corporate, you can't sue the police. Don't ask me why. I don't make up the rules. I'm just telling you what they are. The Supreme Court held that 1983 violations permit suits against a municipality if the municipal custom or policy caused a constitutional violation. We've repeatedly recognized that there can be no liability under Monell without an underlying constitutional violation. Plaintiffs' 4th and 14th Amendment claims require Adams to be a state actor, which in turn requires her to have acted under color of law. However, as discussed above, Adams was not acting under color of law. Consequently, the city cannot be held liable for Adams' personal actions not taken under color of law, and the plaintiff's claims against the city fail. For the foregoing reasons, we affirm. So that is the case of Carrie Yaki Morris and Kevin Galloway versus the city of Detroit and Jennifer Lee Adams. In this case, we learned that if a police officer comes to your door and wants their $300 back, that does not count as police action. So even when they shoot you with their gun, that is not a 1983 violation. So no suing the government for you. And I guess pay your police officer loan sharks on time because they will come get you. So don't borrow from the police, and if you do, pay back promptly would be my takeaway lessons. But that is the end of this case.